And welcome to the Secure Your Creations podcast with Mario Milano. Today, in this episode, we're going to be talking about design patents. And there's a lot of intricacies, would you say, Mario, in terms of design patents?
Yeah, the design patents are a unique aspect of patent law, and so there's a lot of ins and outs, a lot of ways that people sometimes get tripped up or might not be familiar with some of the details. So hopefully, we can dispel some of the myths that are out there.
Awesome. Awesome. So let's start right from the door, right? So obviously, you do this for a living, you're good at it. So I'm going to ask you the simplicity: design patent and a utility patent. What's the difference?
Yeah, so there is a big difference between the two of them. The design patent is going to cover the ornamental features of a product or an invention, where the utility patent will cover the functionality of the product. And so, there is some gray areas where is something functional? Is it a design? And that's something that, your experienced practitioner would be able to recommend and advise you on how to proceed about that. But if it's the look and commercial impression of something, that would be a design patent. And if it's the functionality, that would be a utility patent.
That makes sense. So also let's describe the ornamental. Make sure I'm saying that right. Ornamental and fun functionality. That's a lot of alities and itities. Statement there.
Yeah, they like to keep it pretty difficult to pronounce, but this underlying concepts are pretty simple. Ornamentality and is just the way that something looks. Think about if you had a T-shirt, where do you put the buttons on it? Buttons themselves are going to be functional because they're going to help keep the shirt closed. But where are they positioned on the shirt? What do the buttons look like? You could have round buttons, you could have square buttons, stars. The possibilities for the shapes are endless. And so, the shape of the button is certainly something that we would say is ornamental, because even if you had your star, the square would, probably function just as well, or pretty close to being just as well.
So do you have a real life example that we can kind of cut to here to get people to understand the differences a little bit more concretely?
A real life example. I don't have any images with me, but one famous case that gets cited is the traffics case. And so there, you've probably seen these signs when they're doing construction, and you see it's like a road sign, and on the base it has some springs. And so they tried to protect those springs with a design patent. But ultimately, the court said that, look, those springs are functional because they keep the sign from blowing over, give it some, even though it's rigid, if something hits it or if the wind blows too hard, it allows the sign to, withstand some of those forces. And so ultimately, that was decided to be something that's functional. And so the design patent was held to be, was not upheld.
Wow, that's interesting because I noticed it in driving by, that I was like, why does that thing have springs on it? Never really thought about it. But then now, as you bring it up from a patent perspective, that's pretty cool, actually.
Yeah.
It's funny how the small little details that are patented really goes to your level of expertise in terms of what you do. Talk to me about how the courts see ornamental versus functional designs.
Yeah, so courts usually look at, are there alternative ways of doing something? So with that, the traffic case, were there other things that you could use besides that spring to be able to have something that functions in the same way? And so if the answer to that is no, that's the only thing that you could use, well, then, that's going to be considered functional. If there are other elements that could be used, then, could be considered, that it's usually considered a design element. And so, one of the ways that we can do that is when we file a design patent application, instead of filing it with one embodiment and one showing or one set of drawings for your invention, maybe we say, okay, here's 2 or 3 different ways that you could do the same thing. And so now we have all these drawings in our application showing that, this isn't functional. It was just a design choice that we made, and it's for the ornamentality of it that we went in this direction. And it's evidenced by the fact that we already included all these alternatives.
Wow. So just to make sure that I'm understanding you correctly, you're not just saying, here's one idea. This is where everyone listening, this is where Mario's expertise comes into play. It's not just one you're submitting several to make sure you cover your bases in that long process of getting approved. Would that
Exactly. Yeah, that's exactly it. All these different alternatives that we can come up with will certainly help expand the reach of, your patent that you're going to get, and making sure that your competitors can't really come close to what you're doing. I mean, ideally, when you're applying for your patent application, you think of, okay, what's the best way for me to do what I'm doing? And, file a patent application on that. And then think to yourself, okay, if somebody already had a patent on this idea, what are some ways that I would try to get around it? And, come up with 3, 4, or 5 ideas. And then we can include all of those in the application to make sure that we've really cast a wide net with the patent.
And that consultation is very important. It's important to get in the early, for you to get in early, so you can really kind of nurture them through the process of understanding, here's kind of what the courts think, and you really should be prepared for that.
Yeah, exactly. And one of the things that I see with people who may not be familiar with the patent process, they have this commercial embodiment that they've perfected. They've spent time. They've made it as reliable as they can for as relatively inexpensive as they can. You want to make it efficiently. And so they think, well, I had these other concepts, but, they don't look as good. They don't function as well. They're more expensive to manufacture. And so they think, well, we shouldn't include that because it's not as good of a product. But really, those are the exact things that we do want to include in there, just to make sure that we can get things as wide as we can.
Wow. Good advice. Good advice. So I'm gonna mess up some words here again, and you're gonna hopefully help me. The Ethicon Endosurgery versus Covidien court case. Tell me a little bit about that.
Yeah, that was a case where, we had a design patent at issue, and the court was looking at whether something was functional or whether it was ornamental. And so that was the case where the courts really considered, okay, is there another way that something could be done? And so they, when looking at the design, they ultimately decided that, if there's only one way to do something, then that's going to be considered functional. But if there's alternatives, then that'll be ornamental.
Wow. There's a lot to this. I'm not going to lie to you. There's a lot to it. So tell me about this. Consumer recognition. How often does the consumer recognizing a product help or hurt the design patent production?
Yeah. So for the design patent, the infringement test is a little bit different. So consumer recognition is something that we would probably look to more for a trademark. And then, so, you're starting to think about, like, the Pepsi logo. If you saw another soda can with a logo that looked pretty similar to Pepsi's, then it's a question of, okay, what would an ordinary consumer think? Would they mistakenly believe that this imposter soda came from Pepsi? If so, then that would be trademark infringement. In design patents, we look at, okay, if somebody had these references and they knew about them and they knew who was responsible for manufacturing each, and then they compare the two designs, would they think that they both came from the same manufacturer? And so when we're talking about a design patent infringement, it's more the consumer, it's an ordinary consumer. And the amount of knowledge that they have is considered to be greater in design patent infringement than in trademark infringement. But ultimately, it comes down to, if you're looking at these two things, would you think that they came from the same manufacturer, or would you think that they're the same? And if you think that they're the same, then that's going to be infringement.
Okay, so I'm going to take our two words here: ornamentality and functionality. And which industries, if you can maybe give a brief list or a long list, depending on what you know, which industries are affected by those two different concepts?
Yeah. So, a lot of hardware manufacturers, they're pretty impacted by this because, if you have a bracket and you need to mount your TV to a bracket, or, you have those holes on the back of your TV that are, they're industry standard now. And so if you want to make a bracket that mounts to that, you're going to have your holes in the correct place. And so if one person was able to file a design patent just claiming the position of those holes on a mounting bracket, well, then everybody would be infringing, because it's an industry standard. And if you want to make it a product that actually works, you have to have the holes in that place. And so that would be considered functional. But, other than the placement of the holes for the screws, you could have your metal pieces in an X pattern, a square, oval, rectangle, octagon, all that would be considered ornamental rather than functional.
So in terms of back to the industry conversation, what about consumer electronics or fashion even? How would somebody like a fashion or consumer electronics or an industrial industry be affected by the design patents?
Yeah, so fashion industry is one where we really see design patents are pretty easy to say that something is ornamental rather than functional. Because, if you have a zipper, could you do it with Velcro or, hook and loop fastener, I guess you could call it. Could you do it with a button, snaps? There's all these alternative ways of like closing things. So, whatever element you use is usually considered to be a design element. And your material that you select, there's different materials you could use. There's really no difference between wool and cotton as far as a design patent is concerned. So they would probably be considered equivalents to each other. Wow. And then in the electronics industry, it depends on the materials that you're selecting and why you're selecting them. As long as there's something that's equivalent out there. So like the shape of your laptop, we've done design patents on those, the shape of the printer, the internal workings of how the printer actually works, that's going to be more utility aspect. But the outer portion of it, the part that the consumer sees when the product is sitting on their desk at home or when they go into the store to buy it, that's certainly considered ornamental.
Wow. So there's a lot of, for sure, there's a lot of details in terms of the design patents. Why don't you give everybody just a brief overview of kind of the industries that you work in more specifically, a bit of your background and how someone who may not know that they need a patent should be looking out for in terms of a service like yours?
Yeah. So, I work in some military products, medical devices, some garage doors, vehicles. So you can imagine that for vehicles, there's plenty of design patents that we can get there. Everybody, every time they come out with a new car or even they just upgrade the car design, there's features there that aren't necessarily functional and are just for the looks, right? Every car is going to have 4 wheels and a motor, and you're going to be able to sit inside of it. So the way that the outside of the body looks, or even, some of the inner workings of like, how does the dashboard look and things like that, these are all things that we can protect with the design patent. Things you want to look out for, if you're in an industry that has a lot of utility patents, and so you think, well, everything's been done before, it's going to be hard for us to improve. And one of the areas that I really see that with is with bicycles. Bicycles have been around for a long time. And so a lot of the technological improvements that you might think are new, they've already been done before. But, you can protect that with a design patent. And it's almost helpful when there's a lot of utility patents in a certain area, because then you can say, look, there's plenty of alternatives. The design that we selected is not the only way that you could do it. And therefore, it's ripe for a design patent.
Awesome. Very awesome. One last question. Before we close out the show of this episode, to close out this episode, can you give us, in terms of 3 to 5 tips that people should know on a basic level about design patents?
Yeah. So, number one is you're going to have to use a draftsman. It's not required, but from my perspective, yes, it's absolutely required. The drawings are really the main disclosure in a design patent, so you're going to want to have those done by a professional rather than trying to draw it up yourself. Much like with utility patents, this is number 2, much like with utility patents, you're going to want to refrain from publicly disclosing your design until you have your patent application on file. Design patents, they don't have any maintenance fees. So once you get your patent granted, that's it. You don't have to pay any more money, which is nice. And your patent is good for 17 years. Another thing to remember is if you're looking, you think, okay, this is a new ornamental feature or a design for a product, even if it's a product that's been around for a while, if you're improving the look of it or the overall commercial impression, then that's something that can be protected with a design patent.
Very, very good. Very good. So if anybody who might have an interest or concern about their inventions and need consultation, Mario offers a free consultation, correct? Just
That's
to get
right.
how he can help you.
Yeah, that's right. Always happy to talk it over and make sure that this is the best way forward.
Awesome. And you can find him on milanoip.com. Mario, thank you for your time today. And we look forward to providing you guys more information and intricacies when it comes to patents, trademarks, trade secrets, and copyrights. I'm Craig. This is Mario, and we'll talk to you guys next episode. Have a great day.
Thanks, Craig.